I beg to mention item number 37, Lordship. Lordship, here we need to file one implement petition, Lordship, to implement new DC, Deputy Commissioner, Lordship.
Huh?
In item number 37, Lordship, we need to file one implement petition, Lordship. To
Well, when the matter is taken up, will they make the meeting?
Item number 19, Lordship. I'm not pressing the matter. Lordship.
You can't say you are not pressing a contempt. You have to say it has been complied.
Already complied.
Council appearing on the petition admits that the judgment and order passed by this court dated
3/8/2018
passed in
in WPC number 5190/2008.
have already been complied with, and as such, nothing further remains in the instant contempt proceeding. Taking into account, you are there?
No.
Taking into account above, the instant contempt proceeding stands closed.
Obliged.
Stands dropped.
Please, your Lordship. Lordship, item number 13, Lordship. Item number 13 is infructuous.
Why?
Lordship, the matter relates to retired person from service on different dates as per notification FEC number 2095/47 dated 1/9/2000.
Has the order been complied with or not?
Lordship, my senior has given the instruction that the matter is infructuous.
It cannot be infructuous, no. How can a contempt matter be infructuous? Contempt matter can only be said to be, you can drop the contempt if it is complied with. That's all. Has it been complied with or not?
I have to take.
You
some
take
instruction.
take the instructions. We'll,
Yes.
when the matter reaches.
Wait, please, Your Lordship. Lordship, I beg to mention item number 32 from today's list. My lord, in this matter, we have to file a substitute petition. My lord. We have to file a substitute petition.
Later, when the matter is taken up.
Highly obliged.
One order implement.
Section of this honorable court, Lordship, I felt this ILO for implement of the respondent number 1, 2, 3.
Whom do you want to implead?
Sorry, Lordship.
Huh?
Lordship, for implement of the opposite party number 1, 2, 3. As respondent number, Lordship, 6.
Why?
Because Lordship, NIT agency is the authority, Lordship, for which the land was acquired. Lordship. And respondent number 8 is the one of the activities.
What is your case? Petition for?
Requisition regarding non-payment of Jirat amount, Lordship, regarding Lordship, land which was acquired by the
On payment of?
non-payment of the compensation amount, Lordship.
Who has not paid?
Lordship, there is a competent authority, Lordship. Competent authority, Lordship, who is the ADC, Lordship.
Then?
Now, Lordship, compensation amount was already sanctioned, Lordship, shown against our name. But that amount was not released yet. Besides this, Lordship, they have already notified the 3D notification was also their Lordship.
3D done. 3D
3D
done.
done, Lordship. So we have no objection, Lordship. Even we have already vacated most of the parts of our land, Lordship. But compensation was not paid. Yeah.
So you have made the NHAI party.
Yes, sir. So subsequently on last occasion, Lordship, when this honorable court asked them, Lordship, that who is the authority for whom the land was acquired. Lordship.
Heard Mr. Swensu, the learned counsel appearing on behalf of the petition. None appears on behalf of the respondents on call. This is an application filed for impediment of the opposite party numbers 1, 2, and 3 to the instant application as respondent numbers 6, 7, and 8 to the accompanying writ petition. the basis on which the instant application has been filed is that the land in question have been acquired for and on behalf of the opposite party numbers 1, 2, and 3. Taking
One and
into-
two, Lord. And three is the one of the executing engineers. This is the executive engineer, Lord.
Why you are making him a party?
Because he is one of the lordship member of the lordship compensation for deciding the compensation.
Your question is you are not challenging the compensation.
No.
You want the money. So why you are making number 3?
He may delete it.
Okay. One and number 1, 2, and 3. This court have duly taken note of that the land in question have been acquired as stated in the application for and on behalf of the National Highway and Infrastructure Development Corporation Limited. Pusto. Under such circumstances, it is the opinion of this court that as taking into account the subject matter involved in the accompanying writ petition, the impleadment of the respondent number opposite party number 3 is not required. Be that as it may, the impleadment of the respondent opposite party number 1 and 2 are required for the proper adjudication of the dispute involved in the accompanying writ petition. Accordingly, respondent opposite party number 1 and 2 are impleaded as the respondent number 6 and 7 to the accompanying writ petition. The counsel for the petitioner is directed to file a fresh memo of parties within 3 days before the registry of this court. And the registry thereupon shall make necessary changes in the course title and also update the same in the CIS. I stands disposed. Main petition for the issue notice upon the taking into account the order being passed in the accompanying IA number P23843 of 2024. The issue notice upon the newly impleaded respondent number 6 and 7. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the respondent number 6, newly impleaded respondent number 6 and 7 has a standing counsel by namely Sri C. Burua. And
I
as
already
such,
served a copy of the writ petition to him, Lord, along with this.
namely Sri C. Burua. And as such, he may be permitted to serve extra copies of the writ petition upon him. So taking into account the above, this court gives liberty to directs the counsel for the petitioner to serve extra copies of the writ petition to Mr. C. Burua within 2 days. List the matter after 4 weeks.
Like.
Right.
Item number 1. May I please, my lord, in this matter, I shall have to complete the new incumbent, my lord.
Why?
They are required to be implemented. I have, my lord, my petition, I have sent.
Where is the order? Order. Order for which has been violated.
Violated order, my lord. Dated, my lord, 16/10/2012.
Then?
Passed by this honorable court, my lord.
Now, this order has not been complied with 16/10/2012.
No, sir.
Though I am not in this content petition, I have received a communication order from the present secretary, who is not a party. Lastly, that has been complied.
Nothing remains. Mr. Krishna, the question out here, the manner in which I take up the contempt is, first it is the office which we have been directed by this court.
Yes.
Therefore, the first thing is to see as to whether it has been complied with or not. If it is not been complied with, then the question comes as regards punishment. The punishment has to be for which a notice has to be issued to them, asking him why contempt proceeding should not be made. Delaying the matter for this, if it has been complied with, nothing remains.
And
Content, they have made a director as a party, not a committee.
Mr. The heard Mr. T. Laffer, the learned counsel appearing on behalf of the petition. That SMST Christie, the learned counsel, appears on behalf of the secondary education, elementary education department. Mr. Please, sir. This court have duly perused the order against which this court have duly perused the order dated 16/10/2012, passed in the petition number 414/2011, against the violation of which the instant contempt proceedings have been initiated. A perusal of the order dated 16/10/2012 shows that there was a direction being issued to the director to scrutinize the claim of the petitioner and pass necessary order within a period of 45 days from the date of production of the certified copy of the order by the petitioner before the said authority. It was further directed that the director shall also consider the grievance of the petitioner relating to increment due in the year 2003 and 2004, which according to the petitioner have not been given. Mr. SMT Christie, the learned counsel appearing on behalf of the Elementary Education Department, has placed before this court an order dated 19/1/2024, passed by the Secretary to the Government of Assam, Department of School Education. And in the said order, it has been categorically mentioned that the appointment of the petitioner was made under the condition that the adjustment is made on condition that he or she never claimed the area salary for his or her post past service as rendered. It has also been mentioned in the said order that the past service of the petitioner would be counted for pensionary benefit as per the order of the government. So it was also additionally, it was also stated that the claim for area salary does not arise. So the said order which has been submitted during the course of the hearing is kept on record and marked with the letter X. In view of the order dated 19/1/2024, it is the opinion of this court that the order passed by this court dated 16/10/2012 in WPC number 4144/2011 has already been complied with. Accordingly, the instant contempt proceedings since dropped. The petitioner, if so agree, would be at liberty to assail the same if otherwise permissible under law.
Right.
The order passed by the Director of Elementary Education, Malad, on 17th September 2020, Malad. There is a clear categorical mention, Malad, I am entitled to get salary due to finance, Malad, concurrence.
I said, I gave you the liberty.
Yes,
Malad.
yes.
You want, you challenge it. You see, it is not for this court to execute these orders. You want, you can challenge it. I've given you the liberty. Challenge.
Malad.
Attempt
to- Yes.
In
Very
this
good
case,
is-
this petition is infructuous, my lord, because against that order, page 16. Order first 29 to 2015, my lord. Against that order, my lord, the government has filed review, my lord. Review petition, and that review petition has disposed of, and the process is going on. So this petition is infructuous.
PDB, the legal counsel appearing on behalf of the petitioner that against the judgment and order that the instant contempt application which has been filed against the judgment and order dated 39/2015 passed in WPC number 2921/2015 as well as other writ petition have already been reviewed by this court. So taking into account above, nothing further remains in the instant contempt petition of which the same contempt proceeding is dropped.
Right, sir.
Secondary department, for the secondary.
Secondary department.
SNT Christie, the Land Council, appeared on behalf of the secondary education department.
Three. Item three, I am referring on your response number 4. I have filed an affidavit of it. The direction was to consider his case for compensation appointment, and it was placed before the DLC. And it was placed before the DLC, and DLC 3 times rejected his case because he doesn't have requisite qualifications. So I have annexed all the minutes.
Let us see the order. Where is the judgment? Contempt petition,
It is page number.
this 24, 2016.
Yes.
Yeah.
It starts from page 6. Page 7.
Heard Mr. So-and-so, the
Yeah,
learned
that's
counsel
it.
appearing on behalf of the petitioner. And Mr. SMT Christie appears on behalf of the respondent number 4. Mr. VIP. So-and-so B. Chaudhary appears for the respondent number 1.
Please, your lordship.
The instant contempt application has been filed alleging willful and deliberate violation to the order passed by this court dated 24, 2016, passed in WBC number 2439/2016, whereby there was a direction for consideration of the case of the petitioner in terms with the in terms with the extent compassionate appointment scheme of the government of Assam.
Yeah.
The SMT Christie, the learned counsel appearing on behalf of the respondent number 4, has submitted that an affidavit has been duly filed in this matter, wherein it has been duly mentioned that the case of the petitioner was duly considered, but however rejected, isn't it?
Yes, on 3 times.
Rejected on
Yes,
3
sir.
occasions. So taking into account the above, it cannot be said that the order passed by this court dated so and so. 24, 2016, passed in WPC number 2439/2016 have not been complied with. Accordingly, the contempt proceedings stands dropped.
Lordship, your lordship,
I so agreed with the rejection would be at liberty to approach this court.
your lordship, can I place something? Can I place something? Can I place something? Lordship, I like to file a reply to them.
No,
Because,
they rejected. You file a writ petition.
Yes.
because lordship, in
It
their-
has been rejected, Mr. Counsel. There was a direction to consider. It has been rejected.
neither informed or neither informed to the.
They have put it on affidavit.
Yes.
But it
Look
was
into
for-
the
but
affidavit.
it was after long back 8 years.
So what? That is why I give you the liberty to file a writ petition. None appears on behalf of the petitioner on call. So it is seen that the instant contempt proceedings have been initiated against an order dated for non-compliance of the order dated 27/10/2016, passed in WPC number 3089/2007. Whereby there were certain directions issued to the Director of Elementary Education to forward the case of the petitioner to the Mission Director Sarva Shiksha Abhijan Mission for utilization of the services of the petitioner in a meaningful manner so that she is not denied of any remuneration altogether. Pusto. The SMT Christie, the learned council, planning council of the elementary education department submits that the present director of elementary education is
expired, or the present director is Suranjana Senapati.
Suranjana Senapati. And the respondent contemner who have been arraigned as a party had already expired. So taking into account that the petitioner have not taken any steps thereupon. So, this court is of the opinion that the petitioner may have already got the benefit for which this court is closing the instant contempt proceedings.
Five.
Lordship, order impugn is at page 12 to 16, your lordship. With the direction to pay current and area salary to me, my lord, to ask my lord, but it hasn't been paid now.
Huh?
Page
Where's
16,
that
your
order?
lordship. Last portion. The petitioner shall be paid their current salary by the respondents in the period of 2 months, as well as their area salary shall be paid in the period of 3 months.
In demand of female personnel them till the remaining service. Then what happened?
Nothing has been done there. Regarding the payment, nothing has been
No, I
done.
am not in this contempt, but I have received instruction lordships that petitioners, they were all appointed lordships. And appointed under terms of, they will not claim the area salary. And they have accepted the appointment, they have joined. That is my instruction lordship that I have received. Lordship may kindly peruse this.
Let them place it by way of affidavit, my lord. Because they have utilized our services, my lord. And it's not their case that we have
I
not
have
been
taken
appointed
my
as per the
record of
procedure of
record,
law,
okay.
my lord.
Serial number 1042. Is the petition number 1.
Where's the appointment order?
That particular order, that is not here, but the series is here, lordship. All the case, contact case number 553, all the 9 petitioners are here. They have all accepted.
Let them place it by way of affidavit, your lordship.
Sumitra Borgohain, the petitioner,
No. Our, Rupkor,
please contempt his number.
553 of 2017.
Lordship Rupkumar, Lakshmi Devi, Khargeswar Mohan, Dinesh Fukan, Ruby Fukan, Sumitra Borga, yes, one of the petitioners. Serial number 6. Mamoni Borua, Povitra Gogoi, then Ratul Gogoi and Bina Kumari Fukan.
All are here.
So they were given fresh appointments.
Yes, because they have fresh appointment and they have found a condition that they cannot claim and they have accepted that condition and they have joined and they are working.
Did you file your affidavit?
No, affidavit has not been filed. On this.
Somebody has filed an affidavit. Wait. You bring it on way of an affidavit.
Only problem is that the director that is already an expert
It's okay.
and the present director from the present.
Whatever it is, you just bring on record
Yes.
their appointment order where they have accepted. We
Yes.
close it then. Because earlier also somebody has filed an affidavit as a commissioner and secretary to the government of Assam Education Department.
That then, yes.
Yeah, so this has been done on the basis of, I remember I passed some judgment when I was used to take bench two once upon a time. So at that point of time, there were around 12,000, 13,000
Yes.
teachers who were found. And then the scrutiny was made and all, and there were found one bracket of teachers who have received training and who have also received salary.
Salary.
Some have not at all received salaries and all. So their policy decision was taken how to accommodate them. And thereupon, in many of the cases, there have been appointments being given out there categorically and this with a condition that they would not ask for the area salary.
That is the same thing.
Area salary, and most of them have joined.
Yes, they accepted the condition and joined. Anyway, I will annex all the appointment letters and do the affidavit.
The St. Christie the Learning Council appearing on behalf of the Elementary Education Department that pursuant to the decision so taken by the cabinet as reflected in the affidavit in opposition, affidavit filed by the respondent number one, that is the Commissioner and Secretary to the Government of Assam Education Elementary Department on 19th of March 2019. The petitioners herein were offered jobs
Yes, you are.
with a condition that they would not claim any area salary. Full stop. The petitioners thereupon have joined, most of the petitioners have thereupon joined. Full stop. He's therefore submitted that an affidavit would be filed by the present incumbent director of elementary education, clarifying the said aspect of the matter. So taking into account above, this matter again on 22nd of January 2025. In the meantime, the affidavit we filed
Only Sumitra Borgohain,
have
our
not
appointment
been.
was not approved.
You give an explanation
Yes.
why.
Lordship, 14 and 15 of the same.
What?
I think 14 and 15.
14 and 15 same.
It's not a dis-
Only. Yes,
Same order, huh?
yes, yes.
6. Yes, madam.
Quickly, your lawsuits, lawsuit can you peruse the order dated 24/2/2023. Inspector still has filed a petition for this case.
Yes, any instruction?
I have submitted the copy to the Vedanta Kaushik, my lord. Immediately after this order, my lord, I don't know. A Vedanta copy at the divorce letter. This is the case of area salaries. I see. This is
We have asked for a report from the district level.
Huh?
In this matter, my lord, we have asked for the report from the district level as letter was sent yesterday, the report is yet to come, my lord. Because regarding some compassionate appointment. where
no,
we-
no, compassion abandon, no.
Sorry, yeah, but.
It
cannot
is
compare.
area salaries.
BTBR was an issue, madam. The requirement of a BTBR.
No,
was
no,
an
no,
issue.
no, this is a case of area salaries,
Yeah, the
non
order
payment of area salaries.
Your direction
No, no.
is, you are referring to the order of 24/2017. Mr. Mazumdar,
The
An order has
Date
been
of the
passed by
order is
this
not
honorable
clear.
court.
wherein it says that in the above circumstance, the respondent authorities in the secondary education department is directed to consider the case of the petitioner and pass appropriate orders declaring the petitioner to be regularly appointed teacher and further to pay the area as well as current salary. At the end of the hearing, Mr. B. Talukdar, standing counsel of AS states that as per the advertisement dated, the required qualification for assistant teacher is graduate in math. Likely that firstly, the petitioner was appointed in math and no material has been pointed out that so and so amount. Secondly, if the state are seriously of the view that the petitioner may not be adequately qualified for not even so and so, even if the objection regarding qualification cannot be a reason to expect to be on one hand.
Yes, Harshit Jain.
Madam, I tell you one thing,
All the three
these directions with due
Inspector School
respect
has
to,
filed affidavit.
with due respect to my learned brother who has passed the order is directly against the Supreme Court judgments. That day I was reading the judgment of Ilmo Devi. That's the Supreme Court judgment, 3 judges bench, 2021. Are these not exactly contrary, completely contrary to those directions? If you don't have the qualification, how can they can be accommodated? And were you appointed properly?
Madam, he has been receiving current salary, madam. Only area salary he has not been received. And Inspector of School has already been filed an affidavit stating everything, madam.
What does he say?
He is waiting for superior, pass an order from superior authority. He wants superior authority's order.
Pursuant to the order, there the inspector.
7678 para, madam.
Appointed petitioner the assistant teacher in Bethia at a fixed pay of rupees per month.
This is not the issue of appointment. But এখন affidavit দেয়? এজনই দিচ্ছে। Or lordship, may I file including petition present income then lordships? If lordships permits me. Huh? Including. Pensioner করছে, পয়সা পায় আছে, regular payments আছে। Maybe একটু more-
Yeah, appointed how? How were you appointed initially?
forgot number. It's
The first paragraph of the order, lordship would find.
petitioner was dropped at the time of provincialization of the school. Para 4, the petitioner along with other drop teachers, a repetition. That is a drop teacher.
Drop teacher.
Yes, my lord. Petitioner was dropped at the time of provincialization of the school.
Then
Then he become regularized because
you were regularized.
yes, passed by this honorable court's order.
Where the regulation subject to termination.
By an order dated 17/7/2001 of Inspector School, Nagaon District, it has been provided that in compliance with the High Court's order, passed to.
Where the regulation order?
I have not annexed, my lord. I have annexed only order of this honorable court. Lordship, can we peruse the order dated 28/4/2017, page 8?
That is what I am doing with.
Yes, ma'am.
There are, Mr. Mazumdar, there are four, five teachers. Now, one teacher was, what? The first kind of stipendary. This is not a stipendary. These are dropped
The teachers were.
and they, and very regularized.
Regularized.
Some came to be
Lordship,
regularized.
there was an
Therefore,
order,
Was the
my lord.
petitioner regularized? I don't think
Continue.
so, because the order doesn't say the petitioner and pass appropriate order declaring the petitioner to be regularly appointed,
regularly appointed.
meaning thereby you have not been regularized. Isn't this directly contrary to Uma Devi?
There were particular few cases where the government had conceded to the regularization of drop teachers.
Understood,
Then it was stopped.
that is the judgment of Justice Gogoi,
Yes,
Oh, yes.
where
my
there
lord,
was
2003.
saying that we are going to do some,
yes.
but if they have not been done, can this court direct?
Then there's a letter of the inspector of the schools.
There were
order
certain,
effects.
that order was passed whereby 2003. Thereby there was a categorical direction that they will be doing it in this manner.
Yes.
And many of them have been done,
Recognized,
and some have been left out.
left out, yes.
I think the petitioner seems to be one of them.
One of them.
And as such, the direction has been given.
Then there were also a class of teachers who had come before this court praying for regularization in a similar manner, but Justice Gogoi's orders in a contempt petition is there, which says that we cannot do it if we have not completed the 2 years of service. So those have to go. There was a concession by the state. At that point, it happened. It happened. Now no further. There is another order of that. So many people were then left out.
No, in my cases.
But
everybody
this
has
order,
been
don't you think,
regularized.
Mr. Mujumdar, this order on the face of it, although I am not here to comment on that, wouldn't it be absolutely contrary to the directions passed by the Supreme Court in Uma Devi?
Yes,
Because Uma Devi came 2006.
Six.
What they claim is that they were working in provincial high school and they should have been regularized was the case. Now, prior to provincialization, they were never in our service. So regularizing a kind of service where they had never entered into our service irregularly as such, that issue should not have arisen at all. But during provincialization that took place at that point of time, there was some concession by the government, so we could not have most of them. But these contempt petitions, most of them, my lord, the contemners are now either not in service or they have retired, some have expired.
How can you be in
Contemners.
service? Where?
my lord.
Where are you in service?
I'm still in service, my lord.
Where? If you have you been regularized?
Yes, my lord. Service.
Then what do you mean?
They have filed affidavit, Lordship, can you peruse the
And the
inspector?
contempt was- If the regularization,
Where does it say that you have been regularized in the affidavit? Let's see.
Lordship, kindly peruse the affidavit filed by the inspector school, Lordships,
Yes, Para.
para 6, 7 and 8.
Reveal the
details
petitioner
he
could
has
not
stated.
withdrawn his regular and reviewed.
As per official authorities reveals the petitioner could not draw his regular salary in
Again,
graduate scale pay as the office of the treasury officer Nagaon raised objection against the said order dated 17/2/2001 issued by the inspector school NGC Nagaon as the said order has the dated 17/7/2017 was not issued after the approval of government as well as finance department. The petitioner again filed another writ petition before this honorable court which was registered 1470/2003. This honorable high court passed an order 28/2/2003 directed a respondent authority to take action for payment of arrear and current salary to the petitioner after proper examination of this case of the petitioner. Seven,
Well, you
para-
see, page 9, page 4, page 4, the first 2 lines. The office of the deponent has no scope to consider any regularization of any post without the government approval.
yes,
Pertinent to mention that the issue regarding regulation of accessory or fixed pay teacher is also pending in other districts and of the state, including Nagaon. As such, the government is obliged to dispose of the issue of regularization of the iman. Therefore, the office of the year forwarded the matter to so and so for necessary instruction. So you have not been regularized.
and then Lordship kindly please para 8 that the office of the deponent communication honorable courts directed to. There is an order passed by this honorable court to regularize the service of the petitioner. And as
That
per
is why I
honorable-
am saying. Therefore,
ma'am.
there is no regularization, and if it is
And thus-
regularized, then contempt fails.
Court direction to the
remains in the
government
contempt.
office. That is issued by the memo number requesting the authority to determine the claims by taking consideration of the available records of the country and employee of the school. As such, the deponent is not. My lord, may I take instruction from my client, my lord? Let the matter be listed next week, my lord.
This is the contrary to Umadi.
Now he has been paid, my lord, regularly.
Now are you continuing?
Yes, my lord.
You are
he's
getting
still
some
working.
salary?
Yes.
Huh?
He is not,
Are you getting salary or not?
yes, my lord, regularly
Kindly,
paid.
I think better off withdraw this. Nothing remains. Because if I say, if matter comes up, I will say that this court can't in view of the constitution bench. Correct.
Paper.
With the law now categorically, you see, madam, the problem arises, at that point of time, that might have been the law. But today, can I direct after 2004 2006 4 SCC page 1, can I direct that you regularize them?
No, this is not.
I could
2004.
there is direction means
2000,
how can I
my
put
case
somebody
is-
into contempt?
My lord, my case is before 2004, 2002 order has been passed. My lord,
Madam, the direction is given at when?
this
The,
case has,
the direction is given when? By Justice Budurbu, when? It was given on
no,
17,
Budurbu passed,
24,
17, my lord,
2017.
because I have approached because I have not been received 8 years salary, that's why.
24,
come.
2017. Then
17, yes, my lord.
Then
For-
24, 2017.
Hardly
The
before that I
direction.
have come, my
At
lord, I
that
have
point
come.
of time, the law was
My lord, I
very
have
clear.
come before that because petitioner had earlier approached this court by way of writ petition filing the date WBC number 224/2000,
But
which
madam,
was
the
disposed of by
order
the
you are
order.
asking, madam, the order which you are asking is at page 8. This is the order passed in the year 2017. Can we now say that, okay, forget about Uma Devi, forget about all judgment where the Supreme Court categorically says that the High Court has no jurisdiction? You are getting salary, you are working, work.
Yes, my lord, I am still
Better
working.
keep on working. Don't invite anything. If I say anything, it will have anyway. And if I ask them to file an affidavit, they will file an affidavit. And then they
Yes,
things
written
which
file
is
affidavit.
things which
My
is
lord, I
not
need,
happening
actually,
there,
I need instruction from my client by the time
things which is not
he might
there,
be
if it
receive
does not.
salaries, my lord, various salaries. No, Papa Pare, because I.
So
I
Majumdar,
cannot
you
contact
take
my client, my
instructions as to whether there has been any further order being passed to that effect pursuant to this, because he says that the inspector says the matter was placed before government on
Yes.
16/5/2017.
And
What
here
else
is an
is
order 24/2/2023
There's
also.
one letter from
But
the
it's-
inspector, the same person, madam. Says that Noor Ahmed was allowed to draw a graduate scale of pay by the then
Vidhi Kumar
inspector. Vidhi Kumar Nath. Inspector of Schools NDC in terms of order dated
That is Vidhi Kumar
17/7/2001. Aggrieved, Noor Ahmed preferred the repetition for regular timescale of pay in WPC number 546 of 11. The Honorable Court by order dated 24/17 directed the respondent authorities to consider the case of the petitioner and pass appropriate order declaring the petitioner to be a regularly appointed teacher and further to pay the arrear as well as the current salary. Further, I would like to inform you that the government by notification dated 26/2/2021 allowed the benefit of regular timescale of pay as per ROP rules to 264 numbers of working teacher, including the petitioner, and no area salaries were admissible for the past service of the teacher. That is a 22 order that we find. It is matter that although we represent the department, the persons concerned are no longer there. The advocates are not pursuing the matter. For the contemners, what we can get from the department
What
overnight.
is that? That's an order.
No, this is a communication from the
Inspector
inspector to
School.
the director. When I said that we had called for a report, this was the last report in 2022. Yesterday also, when we got the list, day before yesterday, we made our communications, because these are contempt cases. And they have asked for a full-fledged report as to what has happened, all the documents. That will require a week of. Contemners are not there now, so otherwise it is difficult for us. We can only.
Get me a copy of that. Can you close it? Authentic.
Because this honorable court has already been passed 24/2/2003 one order, madam.
Area salary not. Majumdar, the council appearing
এখন দিছো মই ক্লায়েন্টক দিব লাগিব
it's that pursuant to the order passed by this court on
বাজেটে আমি চাইতাম তাই নিটো কানেক্ট কৰিছে
when 24/2/2023.
yes madam
24/2/2023. The report so sought for have been is awaited. He therefore submits sometime maybe going to again on 4th of January 2025. In the meantime, the report reflects the sort of results.
madam in the meantime I would like to file completing petition.
Then whether you file or not, that is, I think, your lookout. Why should I give you say anything?
Seven.
Same. This is Mr. Christie, this seems to be same. With that item, he was appearing now, somebody was appearing now.
Operating para my lord, page number.
Pointing the same thing.
Yes.
That against that.
Accepted.
Since August 2007.
Our instructions say that the appointment, she was offered an appointment after the verification process and she has accepted the appointment.
Past service enough.
So where she will not be claiming anything for her past services, that appointment has been accepted by.
Have it?
Yeah, that I can give a printer for that, just take a printer.
My lord, already the petitioner service is regularized. My lord, EV.
No. Regularized is okay, but you have been regularized with a condition that you cannot claim the earlier salary.
No, my lord, this subsequent, my lord, prior, my lord, this order. Already services regularized. This honorable court had directed, on the basis of my lord, Retail 301, my lord. The petitioner already availed the full benefit, my lord.
Who?
Those party in Retail, my lord. In the line of same direction, my lord, quantum age.
Where?
Page number, my lord, 21.
Huh?
Page number 21, operating para, my lord, A.
In 21. What is that?
My lord, last, my lord, 22, my lord, seal.
So far as the petitioners in so and so, they stand in a different footing and are not covered by the judgment and so. Reiterate their claim for salaries for the period from September to the, as they claim to have continuously served the teacher till date. Let a similar verification exercise be conducted to ascertain their legitimate entitlement to the area salary. Effect from remand. Direction in this regard expected with a period of 4 months from today. Entitlement is squarely this order shall abstain from proceeding. So you fall in the second category. What is your name?
Bobita Senapati, my lord. August 2007. Bobita Senapati. WPC 3183/2008.
Bobita Senapati.
Yes, my lord.
What is your number? Case number
Page number 8, my lord.
3183.
Yes, my
To proceed as it deemed fit in, and the payment of salary to the swear shall be made in a period of 6 months from the day to day by following a verification exercise to ascertain whether they are in employment as on date as teachers in the school they were serving.
lord.
We are concerned with the direction at paragraph 8.
Yes, my lord.
Let us see what do these people say. Who has filed this affidavit? And the affidavit of Where's the affidavit of this person? There seems to be some affidavit filed, not on record. Don't you think you need to bring in by way of an affidavit this appointment order?
This one, one sample of an appointment order which was issued, my lord. It was a same. I'll bring the appointment order on the record. Just a sample.
I remember the sample I've seen it,
We'll bring it on record.
where they say that this appointment is made subject to the condition that they shall not claim the area.
Any areas.
There is a condition.
Yes.
And when they end that undertaking, they have to give at the time of joining,
We give up all past claims.
isn't it?
Yes.
Bring in those documents. Because he says her case is that she has not received the area and current settlements.
My lord, contaminants number 2 and 3 both have expired.
Okay, you file it and we close it.
One has retired.
Okay, you
We'll get
file the let it be filed by the government, because here the problem arises is you need to bring a closer to this. There is an appointment against that. They have not challenged that appointment because I have, Mr. Mukunda, I filed many judgments earlier to the effect, once you have accepted that, you cannot.
Close, my lord. That is what I said.
So there are many judgments at that point of
Yes,
time.
yes,
I filed. And I don't think anything has happened thereafter.
No, they have not gone for an appeal. Nothing has happened.
Some of the judgments which have there, but it is long time back. Bench two have come again for a long time. Okay, Mr. R. Majumdar appearing on behalf of the secondary education department, that two of the contemners have already expired and the remaining have already superannuated. Be it as it may, this court had asked Mr. R. Majumdar as regards the status of the petitioner's claim pursuant to the judgments and order dated
19-1.
judgment and order dated 19/1/2017, passed in WPC number 3183/2008. The Learning Council submits that the petition herein have been accommodated and brought within the service of the state by regularizing the services of the petitioner with a specific condition that the petitioner has to forego the area salaries. he further submits that the petitioner thereupon have accepted the said appointment order and have also given such undertaking to the effect. If that be so, this court directs the secondary educator, the present incumbent director of secondary education to bring on record the said aspect by filing an affidavit. That again on January 2025.
The elementary education.
Elementary.
Elementary education, we stand for the Department of School Education as a whole. They consider it as a whole.
Director of elementary education. You for Department of School Education.
School education. Now there is no elementary schools, Department of School Education.
This happened
As-
recently,
Madam.
means
No, the-
1.5
this happened
years.
last year. This happened last year, but we were not,
No, that have 1.5 years.
CLC. Department of School
But
Education.
earlier
Department of-
there were two departments.
Now we have higher education and school education. That's two.
I,
Higher is the college part. The higher
there
secondary
Mr.
is-
K.C. Gogoi, K. Gogoi is
Most
there.
of Gogoi appears for the higher education.
My lord, may I, my lord, increase the new income and all?
Why do you, that person has not received the area salary? Why do you further impose? I'm getting this thing done. If you are entitled, you will get it done. Let us see the affidavit. Once that affidavit is filed, so we'll take it.
Item H.
The same, my lord.
Huh?
She was also accommodated. We have to
Same.
take the appointment letter.
Same order.
Next is also same. Next item number 9 is. 9 is also same. Is there? The container is expired. Okay.
Who has expired?
The container Sanjeev Kumar, there is one container, sole container, sole respondent,
Sanjeev Kumar Bhuya.
my lord.
What is that? Same order, same case. Oh,
Just.
what is the
No,
direction?
this was
given?
regarding an area salary. my lord.
Huh?
This was regarding an area salary.
Clearly
And DO
salary
Kacha
to
has
be-
submitted.
salary by passing admin, a salary will be. That is problem.
Otherwise, the department is processing it, madam. We have asked for a fresh fresh area salary proposal.
But that is long time back.
This letter is of 12/12/2024, madam. Some proposal
Understood,
had
but the
come.
order was passed long time back. Order was passed in 2016.
Yes,
Does
madam.
it take 8 years for that?
There was, because there was only one container, perhaps the matter. Perhaps there was only one container. Therefore, the office was not in,
1%.
not in knowledge of the matter. Now that 2024 matters are coming up. This had come up a few, I think a month or two ago, my lord. We started the
Yes, on
process again.
behalf of the, on call, Mr. R. Majumdar submits that the contemner had, and the contemner had already expired, expired. Be that as it may, he further submits that, where in a recent communication, who has written this?
Madam, this has come from the Director of Elementary Education,
Director of Elementary Education has written to the
DEO, Kachar. District Elementary Education Officer, Kachar. For resubmission of fresh area salary proposal.
of the petitioner. So taking into account the above, the Director of Elementary Education is directed to bring on, the present incumbent Director of Elementary Education is directed to bring on record the present status pertaining to compliance to the judgment and order dated 4th of May 2017, passed in WPC number 1167/2016. Mr. S. R. Majumdar, appearing on behalf of this Department of School Education, shall apprise the Director of Elementary present incumbent Director of Elementary Education about the order so passed. That is a big problem with contempt. You can't dismiss for default. You have to bring it to the logical conclusion. 24. Full one. 11. Yes.
Shift one week and will be allowed to file on.
You've been regularized. You want regularization. Why?
Application bottom date of disposal of 4065 of 14. Uttoramana disposal. And 18 content. 14.
Yes, Mr. Mohinder. How can you now regularize?
The last, the yesterday's communication says 12 to 24 communication says that it has been sent to the learned AG's office for an opinion.
Whose opinion?
Learned AG, madam. It means similar, it come down to one of us.
What is he going to do? What is the AG going to do? But it takes, no, I'm saying because these are 2017.
17 order for this.
17 order, there's a direction to the effect that you're regularizing.
Then processes were made. 2023, my lord, the proposal was sent and as per SI format, the inspector of school has shown vacancies. This was sent to the government. Now it was to go to the finance to get the SIU approval so that we can regularize the services. Prior to the finance granting the regularization, it has become a norm that it comes to the office of the AG for his.
But is the government still regularizing?
Court order is- But we do the court order directly to regularize.
Understood. But is the government still regularizing? Under what policy? Does the government have a policy for regularization?
It's because of the court orders. Proceed. Since 2017, no review, no appeal, nothing. We did not file an appeal or a review at that point of time. Now it's too late in the day to.
We take it up again later on, but just find out when there is a direction with this. Political Supreme Court Constitution bench judgment. That the court cannot. The court, the contempt court still bound to ask for compliance.
They will again drop pictures. That's what they also drop pictures. They are also drop pictures.
Oh, drop
If
petitions.
it's-
Yeah, both the petitioners are dropped.
Dropped.
But the case of the petitioners is a bit different. They say that their names were duly recommended by the High Power Committee.
Yes.
But after having referred to the High Power Committee, the High Power Committee has come up and said that it means High Power Committee. But the other people have been duly appointed. But not the petitioner, unless The court holds that they are entitled for regularization as such the direction has been.
The report of the director that we have, it says, later on both the teachers approached the honorable court for regularization of services, and their case was placed before the high power committee. The high power committee has recommended the names of Nilima Nath as a drop subject teacher of education at Rehabari HS School and Srimati Chitralakha Devi as drop subject teacher of logic and philosophy at Pokasoriha HS School, and requested this office for taking necessary action from their end. Accordingly, this office by letter dated 22/1/2020 asked the inspector of schools to submit a SIU proposal showing two clear vacancies of PGT of the respective subject for submission of proposal to the government. Then it says, same was submitted to the government by this office order dated 18/5/2020. As per SIU format, the inspector of schools shown the vacancy as Bojali and Patalsarkusi Vidyapith. This is for your kind of necessary action. So it went up to the government. Now that SIU approval has to come. For the SIU approval, it has now almost become a standard norm that without an opinion of the councils, my lord, either it be from the government council, either under the of AG or unless that opinion is there, the finance again reverse back the file, get an opinion. So perhaps it is now stuck at that point because the yesterday's letter says
Star Modimdar, the council appearing on behalf of the school education department submits that pursuant to the judgment and order passed by this court on 18/4/2017 in WPC number 4065/2014, steps have been taken for the purpose of regularization of the services of the petitioner. It further submits that the matter is presently pending before the SIU before the finance SIU bracket SIU, and opinion have been sought so that the order passed by this court dated 18/4/2017, passed in WPC number 4065/2014 is brought to a logical conclusion. So he therefore submits that some time may be granted in this regard to bring an update to this matter again on 10th of February 2025. In the meantime, the updates be placed by way of an affidavit by the present incumbent director of elementary
no, secondary matter.
secondary education by filing an affidavit. The Mazumdar shall duly place apprise the present director of secondary education about the order so passed here.
Item 12.
May I please lordship?
Yes, Mr. Christie.
Lordship, there's some.
But here there was a sole container. If they have missed out the matter.
And last order, they were supposed to file an impeding petition.
Yes, Lordship. Lordship, Lordship, I need one of time, Lordship. I will file implement petition, Lordship.
Who is to give the financial assistance?
Now that the scheme is gone, Lordship, which is, it is gone, that scheme is no longer exist, Lordship. That time is long back, Lordship.
Understood. This order was also passed long time back,
Order was on
7/6/2017.
The financial scheme stopped from around 2011, under the 11 Act it was stopped. From 12 onwards, no schemes were, no financial assistance were permissible under the law. That, question number was-
Have you filed an affidavit? Have you filed an affidavit to the effect? File an affidavit, there is no financial scheme. In fact, the court should have brought it with you. Wakalatnama filed, but they were not filed this.
There was the respondent, the sole respondent, he has retired from service 4 years back. So they were required to file an implement petition so that we could get the appropriate.
I will file a.
How do you say that the financial scheme helps them?
But the 2011 Act itself says that there will be no financial grant anywhere. After that, we can only give a grant for exceptional educational work by someone, we can give a scholarship or something, but otherwise it is in the Act itself, madam. 2011 Act also, 2017 Act also. Manual ko nasa book. Manual ko doon. Good even. They will not continue doing. Okay, come here. Section 2 ले लो. Section 2 ले लो. Look at section mark.
Which one?
Like that.
You of the Act 2011.
11 Act was already it was stopped. This came into force in 2013, my lord. So people were filing cases up to 2013 asking for financial grant. Matter came to be disposed of in 16. It was not first pointed out to the honorable court that in 13 onwards, nothing was payable to anybody.
This is a non-government education institution.
Financial assistance are granted only to venture educations. Who were not told.
No. Kindly see the section 3(6). Save and accept an institution covered under Article 30
Minority
of the Constitution of India, which is already getting some financial assistance
minority institutions.
or granting aid. No private or non-government education institution shall be entitled to get any aid or assistance except incentive for academic excellence from the state government in any form with effect from the date of coming into force of this act. So never
Five,
meaning,
lordship,
Huh?
just above that five.
Five.
Sub five, madam, last few times. But may be allowed to run as private, and those who were not brought into the provincialization fold will run as private or non-government institutions. And none of them will be entitled to get any financial assistance. So these schools do not come in after 2013. If lordship will have the order, which is, of which contempt is alleged, lordship will find the last few lines. Considering the matter in its entirety, the respondents are directed to disburse due financial assistance to the petitioner within a period of 8 weeks. So on the date of passing of the order, there was no financial assistance. which was
no, but
payable.
let us first see that it is not, it is a non-government non-government institution.
If submit 5 we read totally minor will come into.
No, first of all, here kindly see the verification of that order. Order 9/5/2013 is the order. Page 9 of the writ petition. Of the contempt petition. You have it? Give it to him. You're not helping.
Page, yes, no, page 9.
Page 9, here this is the order passed by the, what do you call this, some director of here, no? Read order dated so and so Assam directing so and so verify the claims of the petitioner school as well as the school of respond number 8 and to disburse financial assistance. Now these statements have been taken. Then says the school headed by so and so has dice code number so and also land measuring so and so having 79 students. The school headed by so and so have no land and it has no student and no dice code. From the above, an research is found the school headed by Abdul Rashid is genuine one to get financial assistance. This was done on 9/5/2013. So therefore, as on 2013 also, there was a question of formulation to that effect. And with this 2011 Act came in the year 2013 and the right to get the financial assistance arose in the year 2012 because there was a direction passed by this court then. You see, first, therefore I'm saying 9/5/2013, page 9, then the page 10C, there is an order passed, order dated 20 of the Honorable High Court passed in so and so. So under such circumstances, so that means at that point of time, this section was not there. As you say, this section or this act of 2011 only came in the year 2013. So therefore, at that point of time, the direction was there. So that was the period for which the financial assistance was sought for.
Special the department on that matter. We can also
Yeah.
section we want so that we can actually. So
For
there's a demand-
punishment, we will impede. First, let us get the instruction, why you have not done it. Then who has not done it, we will impose. Mr. So the learned counsel appearing on behalf of the petitioner, Mr. R. Majumdar appears on behalf of the school education department. First of the instant contempt application has been filed alleging willful and deliberate violation to the order dated 7/6/2017 passed in WPC number 163 of 2016, whereby this court had specifically directed the respondents to disburse the due financial assistance to the petitioner school within a period of 8 weeks from the date of receipt of the certified copy of the order by the Commissioner and Secretary to the Government of Assam Education Elementary Department, failing which the amount of financial assistance would carry interest at the rate of 6% per annum and the same be recovered from the erring officials. Full stop. The Learned Counsel appearing on behalf of the Department of School Education submits that the respondents who are arraigned in the instant proceedings have already superannuated, the respondent has already superannuated. Be that as it may, this court request Mr. R. Majumdar, the learned standing counsel of the education department, school education department, to obtain instruction as to why the order dated 7/6/2017 passed in WPC number 163 of 2016 have not yet been complied with. First, the present incumbent commissioner and secretary is directed to Commissioner and Secretary, Department of School Education, is directed to file an affidavit as to that effect. The Mr. R. Majumdar shall duly intimate the present incumbent so and so. This matter on 10th of February 2025.
This is a contemporary matter. Here we have exact result. There was some area payment method for about 300 days, but we are not in the abdominal video it is found that we have received the same minute, but some missing some amount. Complaint. Honorable Court will not. It's
8/11/17.
Yes. School, education.
Education is perhaps not a party. Education is not a party perhaps.
Another important thing with what has happened in this contempt. Who is number two? Commissioner and Secretary, Elementary Education Department. Not by name.
Therefore, it's not a-
Say, the Commissioner and Secretary Finance says that you say it was wrongly sent, properly not sent, but then also there is a direction being given to the Elementary Education Department to do the needful as per the rules. That is the affidavit which has been filed by Dr. Ravi Kota. If you see the affidavit which has been filed on 12th of June 2018, and more particularly at paragraph number 7, Mr. Rossi, do you have a copy of the affidavit
At present, I have no.
of Mr. Ravi Kota? Here he says that the contempt, the deponent most humbly beg to state that the finance department has already advised the elementary education department to take necessary action as per the relevant rules and guidelines in force dated 5/5/2018. So there is the finance have already mentioned that. And it was forwarded by on 5/5/2018 by the year to the Commissioner and Secretary to the Government of Assam Elementary Education Department.
not a instructions as of now. I don't have any instructions.
Heard Mr. received the learning counsel appearing on behalf of the petitioner, Mr. Armajunda, appeared before the Department of School Education. The petitioners herein are aggrieved by the non-compliance to the judgment and order dated 8/11/2017 passed in WPC number 6695 of the 2017, whereby there was a direction passed by this court to permit the petitioners to encash the leave in their credit after adjusting the amount already paid on such count. Full stop. It is further seen that an affidavit in opposition was filed by Dr. Ravi Kota, who was then the Commissioner and Secretary to the Government of Assam Finance Department, wherein it has been mentioned that that as regards the entitlement of the petitioner, the Elementary Education Department has to do the needful. Full stop. In that regard, he have also enclosed to his affidavit a communication issued back on 5/5/2018 from the Finance Establishment Department to the Commissioner and Secretary to the Government of Assam Elementary Education Department. Full stop. It is also seen thereupon that this court had impleaded by an order dated 13/7/2018, the Commissioner and Secretary Elementary Education Department. However, thereupon there has been no response from the Elementary Education Department. Mr. R. Mazumdar, this court directs the Elementary Education Department, the Director of Elementary Education, or should we ask the Commissioner Department?
At this level, that no.
The Director of Elementary Education Department, the present incumbent Director of Elementary Education Department, to apprise this court as to what steps have been taken pursuant to the communication dated 5/5/2018 by the Finance Establishment Department to the Commissioner and Secretary to the Government of Assam Elementary Education Department. Who's to list this matter again on 10/2/2015, 25.
Item 16,
65
Yes, what is this?
Yesterday, we have been informed that steps for his regularization is taking place. He was adjusted to a school and had been drawing his salary. Commander has found a vacancy. And now we have found a vacancy in one of the schools we were supposed to regularize it. That process is on, my lord. Will become
Mr. R. Mujumdar, the learned counsel appearing on behalf of the School Education Department, that steps are on for due compliance to the order dated 26/2017, passed in WPC number 5101/2012. He submits that some time would be required in as much as the vacancy have already been identified for regularization of the services of the petitioner. We have not been regularized, na? To list this matter again on 17th of February 2025, on which date the present incumbent director of which education department? Elementary? Huh? Secondary? Secondary. Secondary Education Department shall file an affidavit bringing to the notice of this court the present notice of this court the status as regards the compliance to the order dated 26/2017 in WPC number 5101/2012.
17.
Another day, we do not have any instructions. There are no instructions as of now available. The container number 1 expired.
Is the direction? Well, what case you have? You have no, they have asked you for certain documents, you have not submitted, so where is the contempt? Heard Ms. So the learned counsel appearing on behalf of the commissioner. And Mr. R. Mujumdar appears on behalf of the School Education Department. So the instant contempt application has been filed alleging willful and deliberate violation of the order dated 5/12/2017, passed in WPC number 2353/2012. First of a perusal of the order so passed showed that there was a direction issued to the district elementary education officer, Porpeta, in terms of the communication dated 19/6/2017 of the Director of Elementary Education to furnish his report before the director on or before 28/2/2018, and thereafter on the basis of such report of the DEEO Porpeta, the DE Assam was directed to pass order with regard to the prayer of the petitioner made. This court have duly taken note of the affidavit filed by the respondent number 2, wherein it has been mentioned that pursuant to the various directions pursuant to the directions passed by this court, steps were taken by the DEO Borpeta to place DEO Borpeta to the headmaster of the secretary of the special residential school for handicap for submitting the necessary particulars. But however, the necessary particulars were not placed by the school in question, which aspect was duly brought to the attention of the Director of Elementary Education by the communication dated 15/6/2019. The Director of Elementary Education thereupon had also submitted a report to the Commissioner and Secretary to the Government of Assam Elementary Education Department, requesting to issue necessary instructions in that regard as per Section 30 of the Act of 2006. It is further submitted that the speaking order could not be passed as directed by this court due to the fact that the petitioner school have not submitted the required information in the prescribed form as required under the RTE Act 2009. So from the above, it therefore shows that a case for willful and deliberate disobedience to the order passed by this court does not arise. Accordingly, the contempt proceeding stands strong.
Item 18.
Ground by the Guwahati University, but my lord, the regularization and time scale of pay was not given. The lordship, operative part of your lordship judgment is at page 15, my lord. Paragraph 9, page 15.
Yes, have it, who appears for the higher education department?
My lord, in the meantime, my lord, regularization and time scale of pay has been given, my lord. In the meantime, regularization and time scale of pay has been given by the
So
Guwahati.
you don't want Mr. Kikide, the learned counsel appearing on behalf of the petitioner submits that pursuant to the judgment and order passed by this court dated 31/1/2018 in WPC number 6315 of 2016. The petitioners have already been granted regularization as well as time scale of pay. And as such, the petitioner would not further like to proceed with the instant contempt proceeding. Taking into account the above, the instant contempt proceeding stands dropped.
20.
Petitioner expired.
Have also lordship issued a speaking order that he is entitled for an amount of 2,90,917. Perhaps that amount has been paid to the heir. That exact information is not with me, lordship, but we already sent to the order. That he is entitled an amount of 2,90,917 rupees as an area salary.
The counsel appearing on behalf of the petitioner submits that the petitioner had already expired. be that as it may, it has also been submitted that an amount of rupees 2,90,917
Yes.
have already been sanctioned in pursuance to the order dated 9/4/2018.
That order has been issued, speaking order, Lordship, amounting not.
WPC number 71712/2017. In that regard, Mr. S.N.T. Christie, the learned counsel appearing on behalf of the School Education Department, have placed before this court the speaking order which is kept on record and marked with the letter X. So taking into account the above, the instant contempt proceedings stands dropped. I put it.
21. Most of the present in governments already transfer from Nagal Coast, my lord. And I want to give it time for file statement of respondent, my lord.
Have you placed the matter before the SLC? Who is directed to page? Commissioner of Government, Secondary Education Department. The direction was only according to the Commissioner and Secretary to the Government of Assam in the Secondary Education Department shall place the case of a petitioner before the next available for its consideration as indicated above. We done so with some affidavit filing.
My instructions of yesterday say that we have asked for a report from the director.
Huh?
We have asked for a report from the director regarding his applications and all, a detailed
Ah.
report.
Ah.
Once that comes, my lord. Yes. That is from the government, we have that. Government have issue with it.
Did you place it before the SLC? That's all. Because there are certain documents which are enclosed and it's a 2, 3, and 4.
So the direction, it was just remanded back to the SLC. We were not required to, it was the SLC which was required. to-
No. Kindly see page 9.
Page 9,
Or
sorry,
paragraph
para 7.
8. According the Commissioner and Secretary to the Government of Secondary Education shall place the case of the petitioner before the next available SL for its consideration as indicated above.
I'll find it out. 7, I was reading, madam.
Because thereafter, what has happened, he has submitted page 11. He has submitted the judgment, then you see the Joint Secretary has taken certain steps. Then the Commissioner and Inspector has provided everything to the Commissioner and Secretary. So page 28/2018, the Inspector of Schools have given all the documents to the Commissioner. Now, has he placed it or not? That's all. Mr. No, there's some X. Let us see what it comes. Mr. Armodunda appearing on behalf of the School Education Department shall apprise this court as to whether as per the direction passed by this court on 19/2/2018 in WPC number 3678/2015, the case of the petitioner was placed before the, what is this SLC? Before the SLC for fresh consideration. Full stop. And list this matter again on 24th of January 2025 for giving an update.
Here, Lordship, the direction is at page 10, Lordship, in annexure A, page 10. Respondent are directed to take a decision on the letter dated so and so and pay the petitioner his due wages for the period of service rendered by him. That has been considered, Lordship, by this order. He has already been given the fixed pay, Lordship. Then only regarding area salary, we have sent a proposal to the finance. But so where the compliance is, so we have done the compliance, Lordship. On fixation, that part we have done. I tick mark his name, Rohit. Para 14 design.
So this is not for area salary, this is for
No, no.
equal minimum scale up,
Yes.
minimum of the say.
Yes.
This is for on open police.
There is no directly for area salary losses. Only to consider losses, the due wages to the petitioner for the period of service he has entered.
So that is obviously a area salary.
Yes.
Isn't it? For the period he has rendered means he has already done it. Isn't it the case of area salary?
Just now he has submitted that it is already, proposal has been sent to the finance department. Now finance department was a party as respondent number 2, but in the content, finance department is not a party. Allow us to.
Finance is there.
There was a request earlier.
So I know it. I don't go by contempt to all these things. We see the council. Is the first is the question of compliance and then the question of punishment. On the punishment, we will make room about the party. Because these are old matters.
Yes.
If I ask you to engage in plead, by the time to engage
Yes,
in plead, that
Losses,
person
can
will
you
be
give us some time,
transferred.
Losses?
Updated instruction.
Losses,
Request the updated instruction regarding the.
yes,
area.
yes.
That will be
That-
very good.
But yes.
The instant contempt application has been filed alleging willful and deliberate violation to the order dated 10/4/2018 passed in WPC number 4124 of the 2017. Whereby there was a direction issued to the Director of Secondary Education to pay to the petitioner his leave wages for the period of service rendered by him. Also, taking into account that the respondents therein where both the secondary education department as well as the school education department as well as the finance department, this court has requested Mr. S.M.T. Christie, the counsel for the school education department, and Mr. B. Gugoi, the counsel for the finance department, to obtain instruction and place as to whether the observation directions so passed by this court on 10/4/2018 in the PPC number 4124 of the 2017 have been complied with. Mr. B.P. Bora, the counsel appearing on behalf of the petitioner, is directed to furnish an extra copy of the petition, contempt petition to Mr. B. Gupta during the course of the day. This matter on 10/2/2015.
Apply.
23.
Maybe the lordship. Lordship is a contempt case. Lordship, order of this honorable court is at page 10, lordship. Operative part, para 4, lordship.
Yes, now,
Lordship may kindly take our affidavit in reply, Lordship, annexure A, page 31, Lordship. I have inspected my Lordship. Now, my lord, in fact, my lord, it is, although it is written as 27,21,000 at that time, but we have calculated the 31,72,000 is odd, my lord. Out of which payment has been made, but my lord, the difficulty, my lord, for the farm, my lord, could not make it. Now presently 13,29,000 is being paid.
how much?
13,29,000.
13.
35. And
Then-
which I'll pay, well, I have my clear instruction, my lord. Immediately they will pay 2 lakhs, my lord. And then 50,000 per month. If fund comes, my lord, immediately they will pay.
No. ASTC,
Yes,
but they have good buses, huh?
my lord.
They have good buses, silly.
My lord,
Fill up those buses. Give it to him.
Lordship, may I?
Would you mind to take one of those electric buses?
Lordship, I will take instruction.
Take the bus. Electric bus, it will be more than 35 lakhs. Think that. New.
May I, sir? Lordship, as per my instruction, as per annexure A of the academic reply, Lordship, our new is would be 16 lakhs 18,419 Lordship. For instance. Yeah, annexure, even reply annexure.
Mr. Sahiwala, I am not in a position to modify the order. There was a direction to pay initially 1 lakh and 60,000 per month till it is liquidated. Now you say that another 13 lakhs is there.
My lord?
Another 13 lakhs are there.
Yes, my lord.
Of
Because
which you are going to pay 2
although it
lakhs.
was said by lord 27,21,000, but we have met the account. As per us, my lord, is more than 4,50,000 more, my lord.
Maybe, but the question is, now the changing the installment from 60,000 to 50,000.
We shall pay, my lord.
So under such a given undertaking, file an affidavit giving us an undertaking within what time you are going to pay.
Well.
How? Then on the basis thereof, we are going to pass on. Mr. G. and Surveillance, the Learning Senior Council is appearing on behalf of the respondent. I have submitted that an amount of further amount of rupees 13 lakhs and all is liable to be paid to the petitioner, which the respondents are taking steps to make payment. But in certain, but on account of financial stringency, not in a position to pay. This court had duly taken note of that the order passed by this court dated 28/2018 in WPC number 7995/2017 has been clear and unambiguous. And as such, the direction footstep. Further to that, no appeal or any review has been filed against the said order. Under such circumstances, the respondent in the suit petition is bound to make the payment. Taking into account the above, submission made by Mr. G. and Sahiwala, the Learned Senior Counsel, 7 days time is given to file an affidavit, 10 days time is given to file an affidavit giving the details as to how the payments will be made. This matter on 3rd of January 2025.
Deeply obliged.
24.
But you will find the order, I will put, starts at page 8, my lord. We will go from page 10, my lord.
My instruction is that petitioner has drawn the area salary amount. Also, he has also given a written statement to the DO lordship that he has received. But can you verify?
And what remains?
That instruction.
It's the SMT Christie, the learned counselor and learned standing council of the school education department has submitted that in compliance with the order dated 11/4/2018 passed in WPC number 245/2014, the petitioner have already received an amount of rupees 4,11,555 towards the area salary. In that regard, he has placed before this court the instructions which are kept on record and marked with the letter X. Taking into account the above, nothing further survives in the instant contempt proceedings for which the same stands. So,
I'm for one.
Mr. Bigu, he appears on behalf of the finance department.
Okay. And I'm for one and two.
The school education.
25.
Yes, we have already sanctioned an amount of 4,70,210 for payment of special training allowance to Mr. Gogoi. Yeah, na?
You paid the amount. Huh? Has the amount been paid?
We have sanctioned it, we have sent it to the accountant general on 5/12/23. Perhaps they have received receipt by this time. And they are also not present today.
There, none appears on behalf of the petitioner on call. The present application has been, the contempt petition has been filed challenging the, for alleging willful and deliberate violation to the order dated 25/3/2019 passed in WPC number 7864 of 2015, whereby this court had disposed of the petition with the direction to the respondents to grant special teaching allowance as per the order dated 7/5/2014 issued by the Director of Social Welfare Department with effect from 1/3/2010 to the petitioners. Mr. SMT Christie, the Learned Council appearing on behalf of the School Education Department submits that in pursuance to the said directions, the amount have already been sanctioned by the School Education Department on 5/12/2023 of to the tune of rupees 4,70,210 to be paid to the petitioner in connection with the petition and the contempt proceedings. The sanction order is being placed before this court and kept on record and marked with the letter X. Taking into account the above, the instant contempt proceedings stands stopped. Taking into account the above, the allegation of non-compliance to the judgment and order dated so and so in WPC number so and so no further survives, for which the contempt proceedings stands.
Twenty-six.
What is this?
Have to take the party loss. We have to take instruction.
Huh?
We have to take instruction from the party loss.
Wait.
For last order loss, we have to implement the respondent loss. Who are presently for the. It was.
Which order you are referring to?
Page 16.
Huh?
Page 16, Lordship.
16.
16, 1/6.
Regarding what?
Regarding Lordship. Pensionary benefit.
Huh?
Regarding pensionary benefit. Lordship.
Then,
Lordship, can you see page 20, Lordship?
what is that?
Lordship, in this case, Lordship, the petitioner, Lordship, earlier filed this petition, Lordship, whereby Lordship, this honorable court decided not to insist upon the undertaking mentioned in the appointment and regulation order, Lordship, the similar order furnished by councils representing the petitioners reflect compliance of earlier order passed by this honorable court.
Have you been regularized? You have been regularized. Then, what do you want?
Petitioners are directed to take Lordship, affidavit, Lordship, whereby this, the department, Lordship, take.
You were drop teachers. Then,
Then our course has been regularized, Lordship, as per order dated, Lordship. As per order dated, Lordship, 10/6/2018, 2008, Lordship.
then,
And
how can you
minus-
get the whole pension scheme?
Therefore, we may be taken up to the all pension system.
Huh?
We may be brought into the all.
Not
pension
possible.
system.
What has happened to that reference? No case. Now, here the order which has been passed is what? That you should not be insisted upon an undertaking. Isn't it? Have they insisted now after the order? Then where's the contempt?
So the
But if you want that you should be given the new pension scheme, for that you have to file a writ petition.
We have filed representation before the concerned authority.
Representation. What they will do? You are asking for contempt against what?
Senior counsel, Mr. A.R. Lordship did not agree.
Is the allegation, let us see. There is no direction passed by this court for entitlement. Show me. Where is the direction? Leho. The instant contempt application has been filed alleging willful and deliberate violation to the order passed by this court dated 5/12/2019 in WPC number 17/2017. Full stop. The allegations so made in the said contempt application, in the instant contempt application, is that the petitioner pursuant to the order passed by this court dated 5/2/2019 had submitted a representation to the respondent authorities for consideration. The 5/2/2017 non-compliance to the order dated 5/2/2019 in WPC number 172/2017 and 18/2019 passed in WPC number 7706/2017. Full stop. The allegations so made by in the instant contempt application is that pursuant to both the order dated 5/2/2019 and the order dated 18/2019, the petitioner submitted representation before the respondent authorities for compliance for considering the entitlement of pensionary benefits under the provisions of the Assam Service Bracket Pension Rules 1969, but no steps have been taken. And as such, it is the case of the petitioner that there is a willful and deliberate violation to the orders dated 5/2019 and 18/2019. Full This court have duly perused the orders dated 5/2019 in WPC number so-and-so and 18/2019 passed in WPC number so-and-so, wherein there is no direction passed by this court to the effect that the petitioner should be considered in terms with the Assam Service Special Bracket Pension Rules 1969. Accordingly, not the instant upon contempt proceedings is misconceived, for which the same stands dismissed. So and so, yes, for so and so, give your name and put it in golden letters.
27.
Order of the honorable court is case six, Lordship.
What?
Order of the honorable court is case six, Lordship.
What contempt is this?
Uh, appointment on compassionate
We'll
ground.
put 10, 12, the order.
Case six.
Why you are making the chief secretary a party?
Respond.
What? Why are you making the chief secretary a party? Was the chief secretary a party to the petition?
Yes, Lordship.
Where?
Respondent number two in our petition. State level committee represented by its chairman, the chief secretary of the government of Assam.
When?
And Lordship, represented file on 19/12/2018.
When?
Can Lordship, no order has been passed. Till date.
He is not. He is only supposed to place the matter before the SLC. There is not even any direction given to whom. See? Set aside the AI in the meeting held and remand the matter for fresh consideration before the next SLC. Who is going to consider? How can this order be complied with? With due respect. Right, and so the learned counsel appearing on behalf of the petitioner. It is seen that the the instant application has been filed for willful and deliberate violation to the order dated 10/12/2018, passed in the petition number 1299 of the 2016. A perusal of the said order reveals that this court has set aside the rejection of the petitioner by the SLC in its meeting held on 26/8/2014 and remanded the matter back for fresh consideration before the next available SLC. Full stop. It is full stop. It is, however, not mentioned as to who should, it is further not mentioned as to who should. And full stop. It is further seen from the reports that thereupon the petitioner had submitted a representation to the chief secretary, saying that case may be considered and granted an appointment on compassionate ground. Thereupon, the instant contempt application was filed by including one Sri Alok Kumar, the then chief secretary to the government of Assam. It is not disputed that Sri Alok Kumar is no longer the chief secretary and he has long time been transferred out of the said post. Be that as it may, the petitioner have not implemented the present incumbent. In addition to that, it is also seen that the directions are passed by this court dated 10/12/2018 in WPC number 1299/2016. With due respect, cannot be put into cannot lead to identification of the person to whom, against whom a contempt proceedings can be initiated. So accordingly, the instant contempt proceedings cannot be further proceeded with, for which the contempt proceedings stands dropped. So be that as it may, if the petitioner is aggrieved, can very well approach this court by filing a writ petition, subject to being permissible as per the well-settled principles of law.
Item 28.
Like we required to consider the provincial election of the 2017 Act has been rejected.
Heard Ms. So the learned counsel appearing on behalf of the petitioner, and Mr. R. Mujumdar appears on behalf of the School Education Department. The instant contempt application has been filed by alleging willful and deliberate violation to the order dated 17/7/2019 passed in WPC number 1664/2016, whereby this court had directed the petitioners to submit a detailed representation with supporting documents, and thereupon there was a further direction upon the respondents to consider the case of the petitioners. Mr. Armukunda, the learned counsel appearing on behalf of the School Education Department has submitted that pursuant to the order passed by this court on 17/7/2019 in WPC number 1664/2016. An order was passed on 24/1/2020, whereby the claim of the petitioner and for the petitioners and claim of the petitioners for provincialization of their services was rejected. So the said communication, the said order dated 24/1/2020 is kept on record and marked with the letter X. So accordingly, the instant contempt proceedings stands dropped. Liberty, however, is given to the petitioner if to assign the same if so otherwise permissible.
29.
For our, I mean, for our,
R2 is what?
the director of education, rather than director.
You are paying for dead people. You won't get any fees from a dead person. Whom are you going to get ask for fees? Don't tell me that.
29.
59 also complained or had given a.
29, same with that, those fees. No.
No, madam, the one similar to the, just the earlier one. We were required to consider the provincialization. We have done and rejected.
Oh, same.
Rejected by
like this
order
one.
dated 11, yes, one. Separate order was passed.
But that is, but that is, 5. And there is another one, because here there are a lot of other people.
16 persons are there.
That 24/1/2020 is only for 5 persons. And
Item 29 is for 17 persons.
where is that? It's same order, right? Same order, right? खाली ये कौन? Number to belay. 446 only 2000. ये आगो को बोल कर it will exclude. It will 11 December, huh?
11.
About to 24/1 asin 2020 it will 11 December. kept on record and marked with the letter X. This is for. This is for 44. This
Yes.
is which one? 446? No, this is different. 446 is another matter.
Item number 29, the original repetition was number was 446 of 15, containing several persons.
Uh,
And out of them, 17 had come to the, come up with this contempt petition. Entire case was.
Oh, that has been
Everybody was
rejected. X. Here, I got it.
Item number 30, the pension has been, she has received a pension in 2020 itself. Abdul Noor Chaudhary.
Received the pension?
Yes, yes. As per report information received from Inspector of Schools and the principal of the school concerned, the authority that is Director of Pension has complied the Honorable High Court order dated 29/2019 by finalizing the pension case in respect to the petitioner by order number so-and-so dated 2011/2019.
You have a copy? Give it to him. None appears on behalf of the petitioner. Mr. R. Majumdar appears on behalf of the School Education Department. The instant contempt application is filed, they allege a willful and deliberate violation to the order dated 29/2019, passed in the petition number 7138/2019. Also, Mr. R. Majumdar has placed before this court a communication dated
23/2020,
20
March 2020.
20 March 2020, whereby it has been categorically issued by the
By the then Director of Secondary Education.
Director, Secondary Education, wherein it has been categorically mentioned that the petitioner's pension have been duly finalized and he have also been paid. He is also being, and thereupon effective steps have been taken for payment of the same. The instructions so placed is kept on record and marked with the letter X. So, in view of the above, the order passed by this court dated 29/2019, passed in deputation number 7138/2019, having already been complied with, nothing further remains for which the instant contempt proceedings stands dropped to ex derivative level.
Establishment.
31.
Now we are reaching, Mr. Majumdar, we are reaching 2020.
On which time will be allowed to file improvement petition.
What? Yes, representation considered for higher education. No higher education. Yes, tell me when that order has been passed, this we are dismissing it on that count. Now tell me, have you informed whom? Presentation. Okay, we can hear on the- Madam, where is that receipt? Receipt of this document. You have filed an actual additional affidavit, page 4. There's no receipt. How can you file a contempt? And you have submitted this against whom? There is not a receipt, nothing. No. Ms. So the Limit Council appearing on behalf of the petitioner. Yes. The petitioner has filed an instant application alleging willful and deliberate violation to the order dated 37/2019, passed in the application number 8421/2018. So from the materials on record, it does not transpire that the petitioner had served the certified copy of the said order upon any of the respondents to the instant contempt application, who's taking into account the above, as no opportunity has been granted to the respondents to comply with the order. The question of the question of a willful and deliberate violation to the order passed by this court does not arise. Accordingly, the instant contempt proceedings stands dismissed. Huh? Senior come. We want to put the name of the senior. Can put the name of the senior, nothing more than that. You are given an opportunity, you do find these type of things.
32. Lordship, willful and elaborate violation of order dated 19/7/2019, my
What
lord.
is that order?
Page 10, my lord.
Page?
Page 10 of the contempt petition, my lord. Direction and para 5, my lord. Page 11, para 5.
Consider the case for appointment under the scheme of examining the availability of vacancy under the scheme, like examining.
If you want to file a subsequent petition, my lord.
Then you have given, written it to whom?
My lord, they have submitted it to Secretary Government of Assam, Deputy Commissioner of Borpeta, and Chief Secretary cum Chairman State Level Committee. Page 16, my lord. We have submitted it before, Chief Secretary cum Chairman State Level Committee.
Who appears for the year?
I am appearing for the respondent number 2.
No, you-
Yeah, my
respondent number
against
2 is
number
okay.
Deputy Commissioner.
Chief Secretary,
And my lord, so far as order, repetition order is concerned,
that you have
order
nothing
is
to do.
directed the SLC and Deputy Commissioner is a part of the DLC.
Spec out the name of the respondent number 2 and give you an opportunity to make an application for impeachment. Is the only way. This court, the instant application has been filed for alleging willful and deliberate violation to the order dated 19/7/2019, passed in deputation number 6088/2015, whereby this court had directed the case of the petitioner be placed before the next SLC meeting or within a period of 3 months from the date of receipt of the certified copy. It is further seen that from the materials on the court that the Deputy Commissioner of Walpara, this court have duly seen that the respondent number 2 had filed an affidavit in opposition wherein it has been mentioned that the petitioner for a case was duly recommended by the district level committee, which is headed by the Deputy Commissioner. It is further mentioned that the Deputy Commissioner has no role in the state level committee. Also, taking into account that the directions were specifically only made to the state level committee and not to the district level committee or to the Deputy Commissioner in question, the question of any willful or deliberate violation by the respondent number 2 does not arise. Accordingly, the name of the respondent number 2 is struck off. this court have also perused that the petitioner have not taken any further steps to array the new incumbent chief secretary to the government of Assam. So, for due compliance to the said order, the learned counsel appearing on behalf of the petitioner submits that he requires 6 weeks to do so, do the needful. This matter after 6 weeks.
In a week, ma'am.
What? The council, we have 2 minutes time.
My name will be recorded.
Your name will be put on golden letters, don't worry. You see, tell me, how are you going to make you include the new incumbent?
I'm
Have
going
you,
to file
are
a
you not
substitute.
required to put him to notice?
Yes, ma'am.
Can you do the notice in 1
Yes,
week
yes.
and then immediately file? Then, that is why I'm
That was
giving you
not
6 weeks.
Deeply okay.
33.
33, we are issuing the compliance order lawsuit. May kindly give us a 2 weeks time.
I thought 2
weeks,
o'clock.
yes. We are issuing the.
Mr. SMT Christie, the learned counsel appearing on behalf of the school education department submits the compliance order is required, you would be likely to be passed within 2 weeks from today. Taking into account various aspects have already been completed. We shall list this matter again on 6th of January 2024, on which date an update be given by Mr.
Yes.
SMT Christie.
34.
Yes, what is this?
The compliance report of the earlier occasion, their appointment order was, this honorable court, they were required to ask the petitioners whether they will join the service. But the same, that others is only, we accommodated them as tutors.
And without payment area. You have filed the affidavit.
But the appointment order was got on, appointment order, it was. Order at 29 1. In this case.
Putul Chandra Borua. And there is one condition, accommodation teacher will get prospective effect from Iman only, and he cannot claim any benefit whatsoever in respect of past surrender.
And he joined on 1/2021.
So what remains?
But 3 and 4, I have the instruction, they have joined my lord. 2 not joined my lord as per my instruction, my lord. 1, I'm not confirmed.
So you don't want the tutor? You want only the salary? Are you still working?
Yes, my lord.
How are you working?
But 3 and 4 already joined my lord, they are.
Well, it's
working
okay,
with
3 and 4 is okay.
Yes,
What about 1?
1, I'm not confirmed, my lord.
1 has joined. This is the document, 1 has joined.
But my lord, 2, my lord, I have the specific instruction, my lord, on the date when the disappointment letter was offered, she had already attained the age of superannuation.
Premolata Kaur has joined, number 2 has joined.
My lord, my instruction that my
সম্মানপূর্বক নিবেদন এই যে শ্রীমতী প্রেমলতা কোঁৱৰ মহোদয়া চৰকাৰী নিৰ্দেশ মৰ্মত ইমান যোগদান মৰ্মে অমুক প্ৰাথমিক বিদ্যালয়ত সহকাৰী শিক্ষক হিচাপে যোগদান কৰা বুলি প্ৰমাণিত কৰি স্বাক্ষৰ দি
And this is written by the head teacher.
head teacher.
But there is no signature.
It is silence.
I filed then one affidavit, my lord, in this regard.
1, 2, and 3 has already done.
1, 3 and 4, they have given their own signatures.
That is there, but only 2, there is no signature.
It has been given by the headmaster that she had done. The headmaster certifies that she had joined.
Yeah.
But how she gives such a certificate?
Because she retired. Now, what happens if she has retired? Means she will get pension? No. Then what happens?
A fresh accommodation under 17.
Then what is the point of her being given a fresh appointment now?
Retirement.
At the age of 58, if you give, what is she going to get? Means her name.
Under 2017. They are getting it for the remaining period only of the service like that they have. up to 60. For many, after the provincialization orders have come, they retire prior to that. Then the provincialization, they did not get any benefit of the provincialization. And since the posts were personal, then the posts die with their.
Then what is the point of they accepting it? There should be a point of accepting it. What is the point of somebody accepting? Mr. Ike Gupta
Those were-
submits that pursuant to the communications took place by the planning council of the school education department. Mr. Gupta, you have been taking time on this aspect.
My lord, I am a specific instruction that two has not joined.
Then what is this?
My lord, C has not accepted the, this offer, appointment letter, my lord.
Submits that in view of the instructions. So this was given on 29/1/2024. Does it take? We'll take it up at 2. Get your instructions. Nothing doing. Well, no, you can't keep it like this.
My lord,
You have to categorically say yes or no. Nothing more than that. If you have anything, challenge it.
My lord, my instruction is that, my lord, say, offer, the appointment letter was offered to her, she has not accepted.
So therefore you are entitled to the salary.
Yes. Because if that criteria is not there, then my lord, I am entitled, my lord. Because in the appointment letter, there is criteria that they will not claim any back area salary. So then she can-
Mr. R. Mujumdar had by an order of had Mr. Arvind, the standing council of the school department had already placed before this court and certain documents which showed that the 4 petitioners have already been offered the job of have been already offered the job of the tutor upon provincialization, subject to the petitioners giving up all other claims prior to the date of the said orders of appointment. He submitted that all the petitioners have duly accepted those appointment orders and have joined. However, Mr. Ike Gupta submits that to his instruction, except the petitioner number 2, all others have joined. He therefore would like to file an affidavit in that regard. This matter again on 8/1/2025. So that the petitioner number 2 can file an affidavit in that regard. This recording.
Petition number 1, 3 and 4 with assistant teachers two was. Kaneshwar is a tutor. Petition number 3 is a tutor. The rest are assistant teachers. Accommodation.
One is assistant teacher,
Yes. 2 is assistant teacher,
2 is assistant teacher,
3 is tutor,
3 is tutor.
4 is assistant.
Submitted that so and so has been given appointments. It's inasmuch as the petition number 1 is the assistant teacher, petition number 2 is the assistant teacher, petition number 3 as a tutor, and petition number 4 has assistant teacher. He submits that all of them pursuant with a clear condition in their appointment orders to the effect that the period prior to the appointment order shall not be counted for any benefits. He submitted that it's to his instructions, all the petitioners have duly joined. However, Mr. Ike Gupta submits that except the petition number 2, all the other petitioners have duly joined. He therefore wants to file an affidavit bringing to the notice of this court the presence, the said status. This is the matter on 7/8/1/2012.
Oh, pleasure. Conductor.
What is the direction? We come to paragraph 12. Paragraph 12 of the judgment. Accordingly, in order to obviate any controversy, or uncertainty in the matter, it will be more appropriate if the authorities notify the vacancy position showing the backlog vacancy in respect to SC and ST after working out the vacancy. Huh?
Post selection processes have taken place after.
Yeah. None appears on behalf of the petitioner on call. Post- The instant contempt application has been filed, alleging willful and deliberate violation to the order dated 24/7/2019 in WPC number 1959/2014, wherein there was a direction that the authorities should notify the vacancy position showing the backlog vacancies in respect to SC and ST after working out the vacancy. Mr. Armugam, the learned counsel appearing on behalf of the Education Department, Department of School Education, has submitted that the respondent had already expired. Be that as it may, he has submitted that in the meantime, during the pendency of the meantime, pursuant to the order passed by this court on 24/7/2019 in WPC number 1959/2014, there has been more than 3 selection process which have taken place. And in every likelihood, the backlog vacancies have been duly notified. So taking into account the above, and also the petitioners are not represented, it appears that the said standards as submitted by the learned counsel appearing on behalf of the respondent number, on behalf of the Department of School Education, it is to be correct. So accordingly, nothing further remains in the instant contempt application for which the contempt proceedings has dropped.
36,
None appears on behalf of the petitioner on call. So the present petition has been filed alleging willful and deliberate violation to the order dated 29/11/2019 passed in WPC number 8737/2019, whereby there was a direction to the respondent authorities to place before the next SLC for reconsideration of the claim of the petitioner for appointment under the compassionate appointment scheme of the government of Assam. It is seen that neither the petitioners have been representing from the last 2 occasions. Apart from that, the respondent who have been arrayed as parties in the instant proceedings have also is no longer in service, is no longer, both have retired, na? Is not holding the posts in question. No, no. no longer holding the posts. Those petitioners have also not taken any steps in that regard. Taking into account the above and the scope under which the instant proceedings have been taken, the instant contempt proceedings cannot be proceeded with without impeding the present incumbent, which the petitioners have not done, in spite of have failed to do so. Accordingly, contempt proceedings have stopped.
37,
Other response. Present. It's not, there are the questions.
Yes.
Lordship, we try to communicate with the petitioner.
No, your case has to be dismissed. You have, means it has already been complied with. There was a direction to place it before the DLC. It was placed before the DLC on 5/12/2020, and it was rejected because it was done after 1 year. That is if you are aggrieved, you have to challenge it. But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Full stop. The instant contempt application has been filed alleging willful and deliberate violation to the order dated 10/2/2020 passed in WPC number 7523/2016, whereby there was a direction passed by this court to consider the case of the petitioner for appointment under the die-in-harness scheme by placing the matter before the concerned DLC Dhubri and the DLC Dhubri thereafter to take consequential action thereof. Also, it is seen from the records that initially the said order was placed before the respondents by the communication dated 3/3/2020. So thereupon, on account of the outbreak of the COVID-19, the case of the petitioners could not be immediately taken up. Be that as it may, it was placed on it's a DLC meeting held on 5/12/2020, and the DLC could not recommend the application of the petitioner for appointment on compassionate grounds, since the committee was of the opinion that the application was filed beyond the prescribed period of 1 year from the death of the employee. And apart from that, the applicant was found underaged at the time of filing the prayer petition. Taking into account the above, the instant contempt petition account, so it cannot be that the order passed by this court dated 10/2020 in WPC number 7523/2016 have not been complied with. So be that as it may, if the petitioner is aggrieved by the decision so taken in the DLC meeting held on 5/12/2020, the petitioner is always at liberty to assail the same if otherwise permissible under law.
38.
Yes, Mr. Bhattakur, what have you done? Why have you not complied with? Forest? Divisional Forest Officer. How can you regularize him? Consider to regularize. Take your instructions on this. There are many petitions. Take one copy from here. As a Forest Department Council. I'm not saying about number 4. 4 may not be there in service. But you just take your instructions. What is the present status? What have you done? Because this, what they have done, they have, after this order which is being passed, they have only given a copy to everybody. Just take your instruction. Regularization of the casual employment on daily basis in LP school. Petitioner submitted representation, court directed to consider the claim of the as per the rules. That's all. Mr. None appears on behalf of the petitioner on call. Mr. Ibo Thakur, the standing counsel of the Forest Department, appears on behalf of, Mr. Ibo Thakur, the standing counsel of the Forest Department, is present in the court. This court had inquired with Mr. Ibo Thakur as to whether the order passed by this court dated 28/9/2019 in WPC number 4569/2014 have been duly complied with. Ibo Thakur submits that he will take necessary instructions. He further submits he does not have any copy of the contempt application. The courtmaster of this court shall provide a copy of the petition which is there in the file, both copies, during the course of the day. List this matter again on 10th of January 2024 for an update.
39.
Yes, Mr.
Petitioner has seriously ill and we have to implement the new incumbent in place of respondent number, contact number 1. But he is not in a position to come. He is bedridden. He have to be shifted to Bangalore day after tomorrow. So we take some time to implement new incumbent.
already we have taken time, but he could not come.
Mr. Goswami, it's no point making all these people a party. There's an order which has been passed on 12th of December 2024. We closed this contempt petition on the basis of this order, wherein it says that you are entitled to the salary for the period from 6/5/2014 to 31/8/2020. You are not entitled for the earlier period as you did not work. As regards the pensionary permit, it cannot be given as you have, as the second period cannot be taken into account. You may have a right of challenging it by way of a writ petition.
Not received a copy of the.
I'm giving you, don't worry.
And secondly, the petitioner has not worked because petitioner was terminated from service.
Understood, Mr. Goswami, everything is understood. But by way of this contempt petition, I
No, sir,
can't
I
do
cannot,
further.
cannot.
So therefore, it would be better
I will
with
challenge-
this
I will
thing,
challenge- I will challenge.
you need to challenge it. The instance I heard Mr. S.K. Goswami, the learned counsel appearing on behalf of the petitioner, and Mr. R. Mujumdar, who appears on behalf of the school education department. So the instant contempt application has been filed for alleging willful and deliberate violation to the order dated 15/11/2019 passed in WPC number 6702/2019, whereby this court direct the respondent authorities to issue necessary order releasing the petitioner from service forthwith and to undertake the necessary process as expeditiously as possible with regard to release of salary, pension, and other pensionary benefits, etc., to the petitioner as he may be entitled to in accordance with law. It is seen that pursuant to the order passed by this court, an order was passed by the Director of Elementary Education on 12th of December today is 13th. On 12th of December 2024, whereby it was opined that the petitioner herein would not be entitled to pay for any payment following the principle of no work, no pay for the period from 8/9/1997 to 6/5 to 5/5/2014. However, from 5/5 to 6/5/2014 to 31/8/2020, the petitioner would be entitled to receive his salary. It has also been mentioned that as per the Assam Service Bracket Pension Rules 1969, pensionary benefit of the government employee can only be counted for a period during service and not for a work performed beyond superannuation. And as such, the petitioner would not be entitled to the benefit under the provisions of the Assam Services Pension Rules 1969. Full stop. Taking into account the said order passed on 12/12/2024, the same it cannot be said that the order passed by this court dated 15/11/2019 in WPC number 6702/2019 has not been complied with. The said order during the course of the hearing, a copy of the said order has also been furnished to Mr. S.K. Goswami by Mr. R. Majumdar, the Learned Standing Counsel for the School Education Department. The said order, which was also placed during the course of the hearing, is kept on record and marked with the letter X. Accordingly, the contempt proceedings stands dropped. So, be that before parting with the record, this court, however, observes that the dropping of the instant contempt proceedings shall not affect the rights of the petitioner to assail the order dated 12/12/2024, if otherwise permissible under law. You have a copy, take it.
I'll take a photocopy. Court master.
Item 40.
Lordship, the order is at page 9.
What is this? Have you got the money?
Some part payment has been made also.
Then
Some partly complied order, but they have not given a specific under what that they have paid the money. Some part money has been paid, but I have to take
well,
instruction.
isn't would not that be a subject matter of a repetition?
Yes, Lordship.
How can their contempt happen if
Contempt
part has been
in a
done?
miss case,
Right?
Lordship, this order was passed in a miss case, IE application,
That's true, but whether the repetition is pending.
pending. Lordship. In respect of that disputed amount, 1,15,000, that amount only. The rest of entire benefit, that was in the order, it was that it has to be released. Out
You are
of that,
against this contempt application,
Yes, Lord.
against this IA order.
I,
That has been complied with.
they have partly complied, but all amount has not been released.
So therefore, you need to file why contempt petition? Why you are not filing
Sometimes
an
it-
IA out there for
Since the
that
person
thing?
is in immobile state, I have to find from the AG of his laws.
Huh?
I have to take the instruction from AG of his laws. Because the
Right?
person is in totally immobile condition, he cannot speak, even his memory is not there.
Then
4 weeks time may be granted, I will give the.
you file it in the writ petition. What remains here? You say that it has been partly complied with.
Part-
Some amount have been
some-
received.
some-
The court did not specify what is the amount to be paid. So some amount has been paid. If you are entitled to more amount, I think you have to file an IA in that writ petition which is pending. I think that is a better course than to keep this contempt proceedings. Heard, Mr. S.B. Prasad, the learned counsel appearing on behalf of the petitioner. The instant contempt application has been filed, alleging willful and deliberate violation to the order dated 4/3/2020 in IH Civil number 726/2020 arising out of WPC number
657.
6576/2019. The learned counsel submits that pursuant to the said order passed by this court, certain amounts have been duly paid. However, there are certain amounts which have not yet been paid. So taking into account that this court had only directed the respondent authorities to consider and make payment as per their accounts, as per their records, the instant contempt proceedings cannot be further pursued, taking into account that certain amounts have been duly paid. Accordingly, the instant contempt proceedings stands dropped. However, the petitioner is given the liberty to file appropriate application before the writ proceedings, which is presently pending, very alleging that certain amounts have been paid and how much the petitioner further is entitled to. With the above, the instant contempt proceedings stands closed.
Supplementary item 42.
Respondent Provident Fund Authority. The petition was against a state proclamation issued by us in order to cover Provident Fund dues.
And
Lordship, they'll stay in the first instance.
you
and
are who?
direct-
You are the writ petitioner? Who is the writ petitioner?
Chief, I'm appearing on behalf of Jay Kalita and I engage counsel for the petitioners.
You are the petitioner.
Lordship, I'm appearing on behalf of the engaged counsel for the petitioner, Lordship.
Anyways, so you are a proxy counsel of the petitioner. Yes. So you are the petitioner. You are the,
Provident Fund.
now who is filed this application? You have filed this application. You want to be impeded.
Direction from the Lordship. What has happened is, your Lordship, they have said even in their current dues for 8 crores.
Hmm.
For Provident Fund and gratuity.
Hmm.
We have treated that there is some proposal for acquisition. Once they get that money, they'll be able to pay. And our information is that apparently meeting happening today. So the amount of money is similar, will come anytime to see. We just want protection that they don't utilize it. The dues from 2013 to 14, and it's a little difficult for us to trust them. with
No,
the
no,
amount of
no, no, no. First of all, there is no stay here.
Let us stay on the proclamation. The Lordship is.
Where?
Order by-
I don't pass stay order. The next interim order shall continue till the next date, subject to deposit of 30 lakhs. First order taking into account this court stays the notice for settling a failed proclamation dated till the next date, subject to deposit of 50 lakhs by the petitioner to the Assam Provident Fund. So they've given you 50 lakhs. You were earlier, Mr. NC Das was appearing. Now you have taken over. Okay. So now you have got 50 lakhs. Then 30.
They're still not paid.
They've not paid the 30.
There was an order
So
of.
they directly deposit another 30 lakhs by so and so. But the interim order is not there. The interim order passed on and shall continue till the next date, subject to the deposit of 30 lakhs by 14/9. Then, Madam, 16/8/2023 order.
7/11 was considered equals.
Huh?
7/11/24. Own case is considered equality in interim order.
You see, the judge did not look at it, but you see, my order was very specific on 16/8. See my order of 16/8. Give her the records.
Such if they're disputing the amount, so it'll probably be difficult for us, in all fairness, to go ahead with the same property. So what we basically want is the money they get from.
See the order 16/8. Thereafter, one order, the court must have been mistaken that he must have said that. Yeah, yes, 11/11, can you see that? I think the court may not have been brought to the attention that they did not pay 30 lakhs and as such, the order of 16/8.
The names are not protected. So last time, 27/11, we could not bring to the judge. Fault, and therefore the Indian order should be vacated.
There's no order.
Problem is, it's not, will not help us with that, because we can't go ahead with the proclamation. Out, to not be fair. So what we have, in fact, I've instructed the, authority,
They're asking for some 3 crores, na?
they're saying that the
8 crores is not the right amount, there's some amount of that being paid and actually reconciled. We're okay with that because the amount is on the basis of their form that they filed. We have no other information. The employer or the manager, whoever is supposed to fill up a form 1, which is a format, saying that we collected wage. These are what? These are wages that already have been earned by the laborers, and you deduct 12% and you keep it with yourself, you double it, and then you deposit. 2012, they've not deposited.
I'm not going to jail.
Lordship, they've been protected by your lordship. with us
Oh,
saying-
I don't have an
Yes,
order.
yes. Lordship, only protection we are asking.
No, I have only initially I've state the order of sale proclamation subject to deposit of 50 lakhs. So 50 lakhs they have deposited, then comes again, I've directed them to pay 30 lakhs. So that they have not. So understand there's no order. Yes,
20 lakhs has been submitted, Lord, deposited.
what about 30? The
The
court,
rest will be deposited within 1 week, Lord. As per my
as
instruction.
of now, there is no say order.
Lordship, that's not protect us, because they are getting amounts from the acquisition committee, and they will just use all of it. Our instructions are that while the acquisition committee is already complete, money is going to be dispersed to them anytime this week. Get the money, notwithstanding the fact that they've said in the writ petition that moment we get that money, we pay your dues first. Our apprehension is somebody who doesn't deposit wages collected and earned.
Where is Mr. J. Kolita?
Regulator is currently out of station, Lord.
Yes. Where?
He was not aware of the matter, Lord.
Lordship, the
because
matter was listed after 3rd week of January 2025. Lordship,
per
as
last-
per the order dated 27/11/2024.
27 one.
If I may, Lord.
Oh, Mr.
Lordship, then none of the advocates for the respondents were present during the order.
Yes, your lordship, because our names were not reflected.
But as on 27
Seven.
11/2024, you have not paid that amount. And the interim order shall continue till the next date of listing, and it was listed on 27/11, and it was not extended. Isn't it? So there is no stay. First of all, there was no stay from the beginning itself. On 16/8, you having not paid, matter finished. Now, what order do you require, madam?
The extent of dues. Bus, Provident Fund and yeah, they should not disburse that money from the award. that we get.
What award?
The acquisition award money is going to come to them.
Who is going to pay?
Not to the government. The government is acquiring a part of their plantation, which is what they pleaded in their writ petition for Air Force. 150 acres of land of our company, and we get a handsome amount as the value of their land, and immediately after getting the amount, the petitioner will pay the entire amount.
Then why are you before us, not before the airport authority?
In fact, we petitioned to the DC.
Then file an not an writ petition. File an here to the DC telling them that look here, this is the amount we have used out there. We have a first charge out there. And if you don't give us, I'm always there next week sitting in this, take up this bench and get us. But in this matter, how do I pass an order that they will get an money and after getting without the airport authority should not release? Tell me, whom should I direct?
Absolutely correct. I'm not pressing that right. We can't direct somebody who's not been party to it to not disperse. My only prayer is it will be dispersed to them. They must not utilize from that amount to the extent of dues.
Madam, first of all, whether it would be dispersed or not, how do I know? Let it be dispersed, or first of all, why are you not approaching them?
We've approached.
Then what do they say?
Have you not heard until now? We approached earlier on 6th of November.
Because you have to approach the DC.
Yes, on 6th of November, we wrote to the DC.
Oh.
We had, now, so that they've got a meeting today at 4:30.
Very well.
Then the lordship will meet on Monday. My only concern, lordship, should not be that they run away with the money and then. they're
Where
still
will
paying.
they run away? They have it's a tea garden. Na? Tea garden is
Some
functioning.
students are known to run away with money.
Yes, Mr. J. Kolta, will he run away?
They
He's
will not run away, I don't doubt that.
Huh?
Lordship, we keep it next week and we know what's happening.
Another date may be fixed.
What?
Another date may be fixed, Lordship.
May they fix lordship as per the order dated
After-
27/11/2025 or 2024.
Thursday.
After vacation.
After the
Lordship.
vacation lordship, third week of January.
I would like to fix it tomorrow, but Saturday it is closed. We'll have it on Tuesday. First item. And give us on that day, you give us information as to whether you have received any amount. That's all. Take it. The instant application has been filed by the applicant herein, who is the respondent number 234 of the applicant's hearing with the respondent numbers 234 to the accompanying with. The instant application has been filed seeking certain interim directions on the basis that an acquisition amount and certain amounts on a compensation amounts on account of acquisition of land belonging to the petitioner estate to be paid by the collector by the collector to the petitioner. Ms. So appearing on behalf of the applicants herein submits that huge amount of money is due to the applicants by the petitioners. And there is an apprehension that the respondents concerned that the petitioners would take that amount and appropriate without paying the same to dues to the applicants who have to also to the applicants. That too, the amount being statutory. That too, the amount which the petitioner, the respondents, the applicants are statutorily entitled to. So taking into account the above, this court fixes this matter on Tuesday, 17th of December, on which date the council appearing on behalf of the petitioner shall apprise as to whether any amount has been received, and if so, what is the amount? Did you see a party anyway?